Hello and good afternoon, everyone, and thank you very much for joining us today for the webinar presented by the Business Audit Group at Kelly Santini in Ottawa. Our topic today is the Ontario Securities Commission's review of the exempt markets, which includes the much discussed and anticipated potential of equity crowdfunding. And our speaker is Tim McCunn, one of the partners in the business group. The presentation today will last approximately 30 minutes, and we'll reserve a bit of time towards the end to take some of your questions. As the presentation progresses, please do send us in any questions that you have. There should be a dialog box up on your screen that will allow you to type in the questions. And finally, if you would like a copy of today's presentation, please contact him, drop him an email, and he'll be more than happy to send you a copy of the slides later this afternoon once we're done. To introduce Tim, Tim's practice is focused on corporate and commercial and securities law with a particular emphasis on mergers and acquisitions and corporate finance for the technology and life sciences sector. He has advised on over 500 transactions involving the financing of both technology and biotechnology companies across Canada, and has acted as counsel to issuers and venture capital funds. He's fluently bilingual and is repeatedly recognized by Lexpert and other legal directories for his work in the corporate commercial area, corporate mid-markets, and private equity. He has served as a director of several private technology companies and acted as counsel to independent committees of the board regarding the sale of asset transactions. I will now turn you over to Tim.
Good afternoon, everyone, and thank you for attending. So let's get right into it. We're going to talk about what I consider to be probably the biggest change to securities laws in the last, decade. The thing about law is it doesn't really change very fast or very quickly, and that's certainly true for securities laws. But these changes, these changes are important. They're probably the last time I saw changes this important was about 10 years ago, when they introduced what I call the accredited investor exemption. That was a great leap for our securities laws in the exempt market, and I'm going to start by talking a little bit about that, because the existing rules don't change; they're just being expanded. So I do want to put this discussion in that context. The other thing I wanted to, and then we'll get into the proposed changes that the OSC is pronounced on. The other thing that I want you to understand is, what are we talking about in terms of the universe of investors here? So, again, the big one is accredited investors. That's one of the existing rules. We're going to talk about that. That's about 4% of the population is the number that's been quoted to me. When you expand that into crowdfunding, it basically means everybody else. And if you do a cutoff at $100,000 and up, that's expanding to about 6.3% of the population. And when you expand it to everybody below that, now you're at 100%. So as you can see on the first slide, again, just to remind everybody, look, even though you're dealing at a private company, you're not a public company, the security laws apply. They apply to all securities. If you're going to be issuing stock, you got to find an exemption. It's not a big deal. It's always, it's usually always doable to find an exemption. But when your lawyer is looking at it, he's got to, or she's got to, understand what that exemption is. And so that's what a security lawyer does. As I said, the biggest exemption I refer to here is the accredited investor exemption, and I'll get into a little more detail on that. What I first want to make people understand is we've got something in Ontario called a closed system. So the idea here is you're in a box, okay, the exempt market, and it really is accredited investors in that market, okay? That's the box that we're talking about today, the so-called 4%. If you want to go outside the box, that's the public market. And those public markets, the only way you get to them is by issuing what's called a prospectus. And a prospectus, we're all familiar with that. It's a very laborious process. It's expensive. It's a document which basically contains everything there is to know about this company with audited financial statements, MD&A, and all the rest of it. In the box, you don't need a prospectus. And so when we talk about crowdfunding, we're expanding the box. And when we talk about some of these other exemptions like this, what I call the offering memorandum exemption, and some of these others, again, that's going to be done within the box. The idea, of course, is it's always cheaper and easier and quicker usually, to do these selling securities in the box rather than outside to the prospectus. Now, this page lists out, and I'm not sure if my picture is in the way here, if people have my, I'm assuming you can see me on your screen, so if it's blocking a bit, you might not see it. But so it lists out basically the major exemptions that exist today, and the most important one is the first one. It's the accredited investor one, and as I said, this rule is called 45-106, and it was the biggest change in my lifetime in this particular area of securities law. At the time, Ontario didn't go as far as the western provinces, so Alberta and British Columbia included one in 2.9 called the offering memorandum, which in a way, and you'll see why, it's kind of like crowdfunding already. And so I'll talk a little bit about that because that's on the table for Ontario for the first time. Also, Ontario did not embrace, their private issuer was much more restricted than what they did in Alberta and Saskatchewan, where they have a much broader definition of what constitutes a private issuer. They get into something called business associates, close personal friends, that sort of thing. And again, that's on the table for Ontario for the first time. So we'll talk a bit about that. Now, the next one, as I said, accredited investor today is the big one. Essentially what you're talking about is somebody who's well-advised, well-informed, or well-off. That's the idea. So it's a factual-based test, and if you go to the next slide, you'll see it's either you got $1 million in assets, if you're if you have an income of $200,000, or together with your spouse $300,000. That's really the people that we're talking about here. Again, the prospectus requirement is not required for that. The other one that we use a lot is so-called private issuer, and that's anybody, they're not the public, they're related to the company in some way. It's quite a restrictive exemption. On the next slide, you'll see I actually get into a little more detail about what that is. You've probably heard about this one. Anyone who's just doing a private company, usually this is the first go-to exemption. You're restricted to 50 shareholders, and quote-unquote, they can't be members of the public. If you go to the next slide now, I'm going to move right in. I'm sorry if I'm speaking fast, but I want to cram a lot in here in a short period of time. Here is the part of the presentation where we talk about these changes. So the first question is, why are we even thinking about changes today? You probably heard of the Jobs Act in the United States, crowdfunding. Like so much in capital markets, this is really coming out of the United States. Great pressure in the U.S. since the so-called Great Recession started, 2007, 2008, where they're looking at ways to create jobs. And that's what the Jobs Act was all about, and we're going to talk about that. The other thing is in the same period of time, there's been a real slowdown in the amount of money the VCs and VCs funds were investing. So what you had was this introduction in the U.S. of the Jobs Act, and there was two components to it that we're going to talk about today, Title II and Title III. Title III is crowdfunding, what everybody sort of hears about, what the hype is all about. Title II is already in effect, and it's kind of like catch-up to what we already have in Canada, and I'll explain that in a second. So again, the regulators sit there when they write securities laws, and this has been the mandate: investor protection versus efficient capital markets. That has been the fundamental mandate of our securities regulators. What's different now is they've been given, in a sense, a new mandate. They're saying, the legislature is saying, or Congress in the United States is saying, small and medium-sized enterprises are the backbone of our economy. They create so many jobs. They're so important. How can we help them? And so, of course, there's many, many ways, but one of the ways when they look at the securities laws is they say, can we make it easier for them to raise money? And so that's what the Jobs Act is all about. It's a relatively new mandate for security regulators, one I think where it's taking a bit of time for them to get comfortable with, because they've never had that as a mandate, i.e., let's make it, let's have a sort of job creation mandate. And so there's been some resistance, I guess I could say, especially in the United States from the regulators down there. Congress passed the Jobs Act and put a timeline in it for the SEC, the Securities and Exchange Commission, to actually draft the rules, and they sort of been dragging their feet and have missed the timelines repeatedly. But now it looks like it's going to happen. Last October they issued their draft rule and commentary around it, and I think most people expect it to be in place by midsummer, maybe a little later. Wouldn't be a surprise. So my next slide is, okay, well, what are we doing in Canada? So again, in Canada, as I said before, we are looking at it, and we are considering it, and it's a little bit different here because, as I said, in some ways you could argue, at least in the western provinces, there is a sort of a crowdfunding already in existence, and some might even argue it's better than the one being proposed, and that's the offering memorandum. So what we have listed here is basically the three major proposed changes that Ontario is putting on the table. So you've got crowdfunding, we're going to talk about that first. The family, friends, and business associates, again, this is when you're talking about your sort of private company, you're just issuing stock to people you know. Again, Ontario was very nervous about it when it first was expanded in the western provinces to include close business associates and close personal friends. Ontario said that just seems too broad. So let's get, as I said to you before, the offering memorandum, the rights offering is very important. We're going to get into that. So let's talk about the first one, and sorry the slides are a little off here. We've got some corrections to make, but the first one is crowdfunding. And so what I've said here is there's really three sort of major points in terms of regulations. The first one is issuer restrictions, the second one is investor protection, and the third one is portal, funding portal registration. So let's talk about them in order. So the first one is issuer restrictions. In other words, who can play in this so-called crowdfunding space? And the short answer is you got to have your headquarters in Canada. You got to be incorporated in Canada. You can't be an investment fund. And the other very important one is you can only raise $1.5 million in a 12-month period. That's critical. So they're saying, look, this could be wide open. How do we contain it? Well, that's a key restriction in order to contain this exemption in terms of what I call the box. And now the U.S., I think they're going to use, the proposal is $2 million. Here they throw 1.5 million. We'll see what it comes to. I think they'll probably go with 2 in any 12-month period. I think the number is really important because the economics start to play in this thing. The other thing is you're going to be restricted in terms of your ability to advertise. There's no advertising except to direct people to the portal. This is all about the portal, and I'm going to come back to the portal in a second. The other point before I leave this is understand it's 1.5 million or 2 million, whatever the cap's going to be, but you can always issue stock relying on other exemptions. In other words, you can use multiple exemptions, and you're not just limited to one. So remember that. When I talk about a cap, that's only on this exemption. Okay, next slide. The investor protection is also a key one. So they're saying, let's restrict how much money a company can raise, so we build a bit of a fence that way. And then let's build a fence around individual investors so that, we build a fence and control it the best we can that way. And so what they're saying is, look, you can only spend or invest $2,500 per deal, and a maximum for all deals in 1 year of $10,000. Okay, so that's an important ring fence around this, individuals, and so you sort of do the math, and you can raise $2 million, and individuals can only invest $2,000. That's a lot of individuals, and I'll get to that because that goes to the economics. The other thing is your disclosure document. They're saying there's got to be some sort of disclosure document. We're not sure exactly what that's going to look like. Those details are being worked out now. The U.S. rule has a little more detail in it, but it'll be some sort of disclosure document about the business. The financials. So that's a key debate. The idea right now is if you're going to do one, you're going to have at least 1 year's financials. They're going to be certified by management. not really expensive. There'll be a certification exposure, if you will, to management, but otherwise not too bad. And then the idea is if you're raising more than $500,000, you got to get them audited. Obviously now you're into a bigger expense, and that's an area, as you can appreciate, that is much debated. The other one is a so-called risk acknowledgement form that people sign, investors sign. So they want to make sure anybody who's playing in this understands they can lose all their money. There's no liquidity, the usual sort of thing. Cooling off period, again, well-known concept in securities law. It's 2 business days. You can back out of the deal. The other one is ongoing disclosure. You're going to have to do annual financials, but corporate securities, corporate statutes already require that. You got to keep your minutes up to date. The only additional one that I can think of that's in the proposal is you got to keep track of your use of funds. So that'll be interesting when that rule is fleshed out a little more. So again, that's the investor protection piece to it. The big one really is the funding portal, and that's going to be key to this whole system. So the regulators are putting much emphasis on who's going to be allowed to run a portal here. And the key is they're going to have to be registered. So if you're not registered, you can't do it. And if you're registered, really what you're looking at is kind of like a broker-dealer of the internet. Okay, that's what you are. Not everybody's going to be allowed to be registered. You're going to have to. There'll be a process and there'll be qualifications. Who they will be interesting, and we'll have to see how the universe unfolds. But there's, I guess, 4 points I want to make here. The big one is the fraud issue. Correct. Everybody understands our regulators are really concerned about fraud. I call it the Tony Soprano scenario. So, how do we mitigate fraudsters coming into this and it being a real disaster? So that's why they want the portals to be registered, but also they're going to impose some sort of due diligence requirements that these portals have to conduct. So for example, you're going to have to do background checks on officers and directors, or in other searches, bankruptcy, litigation, criminal searches, that sort of thing. We see it in the venture exchange process now. We do so-called PIFs, personal information forms. I mean, there'll be some sort of minimum due diligence requirement. The other one they're saying is just the portal is going to want to have a reputation. If they have a reputation as not being very good at it and not being successful in the companies that are on its portals, that'll go to its reputation and presumably it will be out of business. So that's an important point. The other one is, what other due diligence, though, will be required on the business itself? Do they have to, what sort of, there'll be a business plan review process? What about financial forecasts? Will there be some sort of accountant review as part of the portal process? I mean, that's all sort of up in the air right now and being debated. The other one is due diligence on investors. So can any investor come into your portal? Will there be some sort of process? And the idea is, yes, there will be. You'll have some kind of basic questionnaire to make sure, they have a fundamental understanding of what they're getting into, which will really be, do you understand you're buying, equity? Do you understand that you can lose all your money? Do you understand that you might not even be able to sell this because there's no liquidity, that sort of thing? And if you fail that basic little online test, you're not allowed to participate. That's sort of the thinking right now. And then the question about the portals is, will they have other services? And that'll be interesting, sort of investor relations services, standard term sheets, standard legal documents. That's a key one, my profession, in terms of, anti-dilution provisions, piggyback rights, preemptive rights. What is sort of going to be the basic provisions? So I see we're coming to eating up a lot of time here, so let me jump in. That's the crowdfunding, and I'll come back to crowdfunding at the end when I give my own personal prognosis of where I think this is going to end up. The other one is the family and friends. As I mentioned to you, it's pretty restrictive right now in Ontario. It's a little wider in British Columbia and Alberta. And so Ontario, and this is kind of in the spirit of harmonization between provinces, that we may adopt the sort of Alberta rule. It's basically sorry, I'm trying to get the other slide. It's basically a much broader definition of close business associate, close personal friends. It's quite broad. It sort of gives lawyers headaches because what's a close personal friend and what's a close business associate. But it's again, as I mentioned before, it's the opening and widening of that box, so it'll be helpful in terms of companies raising money. The next exemption, though, that I think will have probably the biggest impact in Ontario is going to be the offering memorandum. As I said before, it's kind of a crowdfunding exemption today. There are restrictions around it to kind of ring fence it, but understand it's not like a prospectus. It's an offering memorandum, and there's no securities regulation review. You simply follow a form, and you go out and you can raise money based on this exemption. There are restrictions. Again, it's similar to crowdfunding, $1.5 million per year by a company. It's got to be Canadian companies, and you can't advertise. Investor protection, again, $2,500 per investment, so $10,000 a year. Again, the ring fencing, how much of this can be done, cooling off period, ongoing disclosure, risk acknowledgement. So again, it's extremely similar to crowdfunding. The only difference here is it wouldn't be done through a portal. It's going to be done through the usual exempt market. If you got someone in the business of selling securities, they're an exempt market dealer, and they got to be registered. There's a little concern about the exempt market dealer category these days in Ontario, but unless the rules change, that's the way these securities will be sold. The next one that I wanted to touch upon that I think will be, so we can just back up. Yeah, so this one is not so much your private companies, it's really your public companies. It's called a rights offering. It's not really used much now because it's a little expensive, it's a little bulky, it's not great. There was a proposal, to sort of make it a little better, but you still got to do a document and put it into the OSC for review, and so it's a little bulky, a little expensive, and not great. They want to tighten up those rules a little bit, and on this slide you see what the proposed rules are. But the really big one here is going to be an exemption that says, look, if you're already a security holder, you're already a shareholder in one of these companies, you should be allowed to buy more stock in the company without going through the prospectus or even a rights offering circular. So that could be, I think, huge. We got a lot of venture exchange issuers out there, especially in the technology business. So that could be a very, very big area, I think, for companies to raise money, because it should make it easier and cheaper to do so. You must be a shareholder for at least 60 days, but otherwise it's going to be fairly straightforward. If you're a shareholder, you can raise money. There will be, again, limits on how much you can do here, so they do want to ring fence it, but but I think that'll be used. So just to summarize, if I can, these are important changes. There's a ton of hype around the crowdfunding. We'll see where it comes. Can't hurt in terms of where I sit, which is I act for issuers raising money. This can only help. People question the economics of it. How much is it going to cost me to actually do it? And with $2 million, if it's 1.5 or $2 million a year, is it worthwhile? I'm saying, why not? It could be. The headache is you're going to have all these shareholders, and believe me, that can be a headache. Just ask anybody with a lot of shareholders in a private company. What's the prognosis? Again, everyone was sort of talking about the fraud thing for crowdfunding, but some people are saying, it's not so much the fraud thing. It's, look, investing in private companies is really risky. And they say what's going to be a real damper on this thing is going to be the number of failures. I mean, anybody in the VC business understands this. We had an explosion in VC funding, VC funds in Canada. Starting in the 90s, we had really none before that. And a lot of them didn't do very well. And so why will a platform doing crowdfunding be any better than them? In other words, I think most people understand the rate of failure when you're talking about these things is very high. And so some people think that's what's going to really be the damper on crowdfunding, not fraud. It's an interesting question. We'll see how it unfolds. The United States is always interesting to watch because it's just the biggest, deepest, most sophisticated capital market in the world. And so how it goes, I think we will go. The status in terms of where we're at, as I said, we expect the rule in the United States to come out in the late summer. I would expect, and there hasn't been an update that I'm aware of publicly yet from the OSC of where they think they're at. I would expect our timing would be similar, probably shortly thereafter. There are a bunch of sites out there already gearing up for it, Fundle Up, Circle Up, Crowdfunder. There's also the, where crowdfunding, you hear about a lot of Kickstarter and Indiegogo, but those are not equity crowdfunding, right? It's about what we call merchandise sort of crowdfunding. It's not the same thing. But there are already the equity crowdfunding sites gearing up, and I hear there's quite a few of them. So that's where I'm going to leave it, folks. Again, thank you for showing up, and I hope that was informative. I hope the technology worked and my picture showed up, but if it didn't, well, you were spared that. There were a couple of questions I got from the audience, and I can't spend much more time on this, but the one was about bioscience pre-revenue. What's the issue there? And frankly, there's none. Startups are startups, and just because you're a bioscience from the securities law perspective is irrelevant. The other one, someone asked about what other provinces are doing. The Western ones have shown themselves to be quite advanced and a little looser, if I can say that. Saskatchewan, I believe, has already come out with a crowdfunding rule, and other provinces are looking at it. But it seems like Ontario is one of the further advanced. But I would expect that others would do the same. Ontario, of course, also is the biggest sort of capital market in Canada within the provinces, so that's not unimportant. And again, the third question here was harmonizing provincial regulations, so same question. So again, I expect that most people will follow that, and we'll see that that happen over the course of the next 12, 18 months.
We have, thank you very much, Tim. We have a couple more questions that have come in, and please do send them along if you do have more questions for Tim. General question, what types of projects are most suitable for crowdfunding?
That's a very good question, and, that's going to be a question that every portal is going to have to answer. And I think what we might end up seeing is specialization in portals, so because the portal is going to be key to this process, and will there be some that will claim themselves to be life science portals, and some to be telecom portals, or retail product portals. I think Circle Up, for example, sells itself as a retail product portal. So the short answer is I don't think there is one. I think what will happen is portals will try to distinguish themselves by picking areas where they feel they have some sort of track record and expertise.
Okay. Thank you, Tim. We have a question. I think you mentioned a few crowdfunding portals that are setting up. There was a question. Can you give us, perhaps just repeat some of those names of the crowdfunders to follow up with that you're aware of?
Yeah. So I think there's one in Canada called InvestX. That is trying to get up and running. The other three that I mentioned was Fundable, Circle Up, and Crowdfunder are the ones that have been brought to my attention. I assume Kickstarter and Indiegogo will morph into this area, but I don't know.
How many equity crowdfunding shareholders can be in the company? And what are the shareholder agreements contemplated?
Yeah, so that's a good question. Again, do the math. So if the limit is $2 million per year, so I guess the short answer is there's no limit. There's an economic limit per year. You could do $2 million every year. every 12 months. So just do the math and divide, and you can see the number gets quite high. And that's the problem I think some people have. Can you imagine, having 400 shareholders? It can become a real challenge. And sorry, in terms of shareholders agreement, there is no one's talking about shareholders agreement. And again, I think the portals might insist on some sort of shareholder rights. I mentioned preemptive rights. I mentioned piggyback rights. Those sorts of things may be things that a portal says, if you want to sell on my portal, you got to give the shareholders.
And just one last question. Can you remind me of what the limit of capital that you can raise to the accredited investor exemption?
There's no limit.
Correct. Well, that's a good way to finish up. Thank you, Tim. Thank you for everyone who joined us. We had a great turnout of people showing the interest that there is in crowdfunding, great turnout from people in Ottawa and throughout Ontario, but also in other provinces. We hope the weather's slightly better than where you are than it is here, but somehow I doubt it from the look at the weather forecast. Again, if you'd like to receive a copy of today's slides, please just drop Tim an email, and he will be more than happy to send them off. So thank you, Tim, and thank you again, everyone, for joining us today, and enjoy the rest of your day.